Good afternoon, everyone, and welcome to today's webinar, the Florida Telephone Solicitation Act, a class action trap for the uninformed. My name is Alex Sabo. I'm a principal in the Florida office of Bressler. With me are Kirsten Nowak, Kaylee Manigli, and Taylor Bandy. They'll be doing the laboring oar today in terms of the presentation. But before we get to the presentation, I just want to tell you that it was 20 years ago today that Bressler came to FLA. Yeah, 20 years ago, Bennett Falk, Keith Olin, and I opened the first Florida office of Bressler, and actually the first office of Bressler outside of New York and New Jersey. Of course, now the firm has offices in several states, but we opened that office. It was January the 24th, 2004. We were in a temporary location in downtown Fort Lauderdale in a building just north of the federal courthouse. We moved into a permanent location in a town called Miramar. Actually, when we moved into that location, we were surrounded by cow pastures with cows in them. Now that location is surrounded by high-rise buildings. Well, we eventually decided we needed to move back to Fort Lauderdale to be closer to courts and closer to the FINRA in Boca Raton, and so we did. So 20 years ago today, and we've certainly enjoyed it. And today you're going to see three of the lawyers who hopefully will be with us 20 years from today doing another presentation. So today's presentation, like I said, the Florida Telephone Solicitation Act, we're going to talk about this law, which seemingly for 30 years was there and nobody seemed to focus on it. But in 2021, as you will learn, the legislature made changes, and those changes became fascinating to the plaintiffs' class action bar in Florida. In fact, it became the darling of the plaintiffs' class action bar, and it still is to some extent, even though some changes were made in 2023, as we'll discuss. That sort of made the statute not as less attractive, but certainly brought into play things that if you potentially are sued, you need to know because you need to be able to defend the case. We'll talk initially in the beginning a little bit about the Federal Telephone Consumer Protection Act and how it differs from Florida's act. But having handled cases pled as class action under both federal and state law, I can tell you that what I've found is that it's very important early on, as soon as the case is filed, get your arms around the facts of the case. Exactly what contact was made, who made it, how was it made, what was said in the contact, because that obviously will drive the defense of the case and may lead to a very, very early resolution. For example, Taylor and I worked on a case brought under the Florida Telephone Solicitation Act, and we filed a motion to dismiss the initial complaint. Well, they filed an amended complaint, again, seeking class action status, so we moved to dismiss that complaint. We had a hearing in front of a trial judge in the Circuit Court of Broward County, and essentially what we argued was that the contact our client made, which was laid out in the amended class action complaint, didn't fall within the definition of the statute for sales solicitation. And you know what? The circuit judge said, I agree. I'm dismissing the case as a matter of law right out of the box. And away went the class action complaint. It was gone, dismissed with prejudice. The other side didn't appeal, so we got a dismissal right out of the box. But we could only get that because we knew what the facts of the case were and how the contact was made. And that's what drove our motion to dismiss. So now I'm going to ask our presenters to introduce themselves in the order in which they will speak. So Taylor Bandy, please step up to the plate. Tell us a little bit about yourself and what you're going to talk about.
Good afternoon, everyone. My name is Taylor Bandy, and I'm an associate based out of Bressler's Fort Lauderdale, Florida office. Today, I will be giving you guys a brief overview of the Federal Telephone Consumer Protection Act and how that act led to Florida's Telephone Solicitation Act, and just a little brief history on that ahead of the major amendments in 2021.
Thank you, Taylor. Our second speaker is Kirsten Nowak. Kirsten, please introduce yourself and tell us what you're going to address.
Good afternoon, everybody. My name is Kirsten Nowak. I am an associate in the Financial Institutions Practice Group at the Fort Lauderdale office. Today, I will be speaking about the 2021 amendments to the Florida Telephone Solicitation Act, as well as the 2023 amendments and the ramifications of those.
All right, thank you, Kirsten. And last but certainly not least, Kaylee Maniglia. She will be our third speaker. So Kaylee, please introduce yourself and tell us your topics.
Thank you, Alex, and good afternoon, everyone. My name is Kaylee Maniglia, and I'm also an associate in our Fort Lauderdale office. Today, I'll be discussing some of the attorney's fees provisions that are provided under the Florida Telephone Solicitation Act. I'll also be discussing how the effective date of the 2023 amendments impacts cases that maybe did or did not have class certification before those amendments took effect. And then I'll also discuss some of the key steps you should take if you find yourself defending against or being a business that's been accused of violating the Florida Telephone Solicitation Act.
Okay, thank you, Kaylee. All of you, I'm sure, are very familiar with the fact that at the bottom of the screen, there's a Q&A button. So if you have a question, please send it along. To the extent we can answer it at the end of the webinar, and we have time to do so, we will. If we don't, we'll try to get to it within the next several days. So without further ado, here's Taylor.
All right, thank you, Alex. So the Federal Telephone Consumer Protection Act of 1991 was signed into law by President George H.W. Bush. This legislation was a response to the steep rise in harassing, annoying, and unregulated telemarketing calls and faxes. The main purpose of the TCPA is to restrict the solicitation via telephone, so for example, telemarketing, and regulate the use of equipment that automates phone functions. Any business, person, or entity that is conducting telephone solicitations must comply with the TCPA. There are several limitations that the TCPA imposes. So the TCPA will limit the use of automatic dialing systems, artificial or pre-recorded voice messages, SMS text messages, and fax machines. It also specifies several technical requirements for fax machines, auto dialers, voice messaging systems, and the main requirement is that you have to identify and provide contact information for the entity that is using one of those devices. The TCPA defines telephone solicitation as the initiation of a telephone call or message for the purpose of encouraging the purchase, rental of, investment in, property, goods, or services, which is transmitted to any person. The TCPA includes 3 exceptions to this. If the company or person has received the prior express invitation or permission to call the individual or company, whether there's already a established business relationship between the company and the individual, or if the calls are made to a tax-exempt nonprofit organization. The TCPA is known for its narrow, industry-favorable auto dialer definition. So an automatic telephone dialing system is equipment that has the capacity to store or produce telephone numbers to be called using a random or sequential number generator, and it has to have the ability to dial those numbers. A few of the other high-level requirements of the TCPA are that callers may only call residential consumers between the hours of 8 a.m. and 9 p.m. based off of the recipient's time zone. This is really important because Florida, for example, has multiple time zones, so businesses should always be aware of what time zone, not just what state, the persons that they are contacting reside. Auto-dialed marketing calls and texts to cell phones and other devices where the recipient might be charged for those calls or texts are absolutely restricted without the prior express written consent of the individual. And a caller must identify themselves. That means they must provide their name, the name of the company who they are calling on behalf of, and a phone number or address that can be used to contact them again. The TCPA created the National Do Not Call Registry. This registry, any person can go online, register their phone number, you verify your phone number in the registration process, and then you can submit complaints. The TCPA, based off of complaints they receive, will investigate as to whether there's a violation. The fines from violations range from $500 per violation, $1,500 per willful violation, and $43,000 for do not call list violation. It's important to note that the TCPA has uncapped statutory damages, meaning the only limit on how large a penalty is how many times violations were committed. There is also a private right of action. So in addition to the TCPA, Florida has its own Telephone Solicitation Act. It has been in effect since 1990, but it really has not gained any notoriety until July of 2021, where the act was amended to allow for a private right of action, which allows consumers to sue for between $500 to $1,500 per telemarketing call or text message that violates the statute. As with other Florida statutes, there is no cap on damages for the Florida Telephone Solicitation Act. And there are remarkably few court decisions out there interpreting the act. The legislative history that is available confirms that the FTSA was intended to apply to interstate communications. In 2021, or pre-2021, there were several safe harbors to the auto dialer recorded message that, reduced a company's liability. Examples are calls made in response to calls initiated by the consumer or called party, calls made to screened or unlisted numbers, and against the Florida state's no call solicitation list, and calls concerning goods or services that were previously purchased by the called party. Now, after the 2021 amendment, communications may only be made to a person or entity with the prior express written consent of the called party. And so that means you must have a signed or digitally signed writing that includes the telephone number you may contact. So the removal of these safe harbors resulted in many businesses in Florida getting served with class action lawsuits for normal customer contact. So Florida's Telephone Solicitation Act has become known as Florida's mini TCPA, and it came out of the 2021 amendment that allowed the private right of action, and all of these amendments that we've been discussing came out of a US Supreme Court decision called Facebook versus DeGuide, and that was issued in April of 2021, in which the court unanimously held the TCPA only covers random fired calls and texts to cell phones from an automatic telephone dialing system. So this decision overturned a US Court of Appeals case in which the appellate court broadly defined the type of automatic telephone dialing systems that were covered under the TCPA. So it's important to note that nowadays, any company making telephonic sales calls from anywhere in the US to consumers located in Florida are subject to the FTSA. And so that what determines whether someone's a Florida resident is the area code of their phone number. So it's very important to remember that Florida's definition of an automatic dialing system is broader than the TCPA's. So just because you are not subject to the TCPA's restrictions, you may still be liable under Florida's Telephone Solicitation Act. So our first CLE code of this webinar will be 20th.
Thank you, Taylor. So Taylor will be back with us at the end to give us a little summary of about what she spoke. But I just wanted to emphasize one thing, and it's that legislative history is very important. Sometimes it's difficult to find legislative history in Florida, but in connection with the motion to dismiss that Taylor and I filed in the case that we handled under the Florida Telephone Solicitation Act, we were able to find some legislative history suggesting that it was not intended to apply to healthcare providers. And so one of the arguments that we made was that we're dealing with an eye clinic. That's a healthcare provider. Obviously, the act doesn't apply to healthcare providers because they have to be able to contact their patients in regard to issues. And in that case, it was a text message reminding a patient that the patient had unused benefits that they could use either for eye exams or to buy glasses or contact lenses by the end of the year. And that's what the big hullabaloo was about. Of course, all within anybody who's handled a Telephone Consumer Protection Act or Florida Telephone Solicitation Act case can tell you, you think the world as we know it was coming to an end because somebody got a text message or an unsolicited telephone call. So the other thing I'll tell you is that before the federal law was enacted, my mother, who was in her late 70s and early 80s, she used to love to get calls from people who were soliciting. And she'd listen to them patiently and ask a few questions. And then she would love to say, well, of course, I don't make these decisions. You'll have to talk to my son, and he's a lawyer. Well, the next thing that happened, of course, is they'd hang up. They didn't want to talk to her anymore after that. So, but she used to enjoy that. And she would enjoy, when she'd come to visit in Miami, she would enjoy coming to tell us stories about who she had received calls from and what she had said to them. So it's not the end of the world as we know it, but I realize that it can be annoying for people. So remember, code number 1 is 20. And so now let's turn to Kirsten. And Kirsten, tell us about 2021 and how it seemed like the end of the world as we know it if you were sending out messages. Kirsten?
Yes, thank you, Taylor and Alex. As Taylor mentioned, I am going to speak briefly now on the 2021 amendments, and then we're going to dig deeper into the 2023 amendment. So in July 2021, the FTSA was amended to create a private right of action. And those were for texts and calls that were sent through an auto dialer without prior express written consent, which gave rise to an onslaught of individual and class action litigation in both state and federal court. This led to an influx of approximately 500 complaints filed within the first year. The FTSA imposes strict opt-in requirements and heavy penalties for failure to obtain a Florida resident's consent. The bill made 2 significant amendments to Florida's previous telemarketing laws. As Taylor touched upon, there is now a private right of action and the requirement for prior express written consent if the call is made using an automatic telephone dialing system. The FTSA then went on to define the prior written consent as a written agreement that bears the signature of the called party, clearly authorizes the person making or allowing the placement of a telephonic sales call or text message to use an automated system for the selection and dialing of the number, includes the telephone number to which the signatory authorizes the telephone call to be delivered, and includes a clear and conspicuous disclosure informing the called party that by executing the agreement, the called party authorizes the use of an automatic system for the selection of calling their phone, as well as that the written agreement or the agreement to enter into such an agreement is not a condition of purchasing any property, goods, or services. Prior written consent that meets the technical requirements of the FTSA is the only defense to avoid liability under this law. The 2021 amendment also went on to define the definition of an auto dialer. An auto dialer is defined more broadly than the TCPA auto dialer definition, which is defined as an automated system for the selection of dialing or dialing of telephone numbers or the playing of a recorded message. Companies must consider whether their current dialing system qualifies as an auto dialer. Capacity for random or sequential number generation required under the TCPA's definition is not part of the FTSA auto dialer definition. It is possible that predictive dialers used with random or sequential number generation that meets the definition of an auto dialer. An individual can now bring this class action claiming that he or she did not provide written consent on behalf of all individuals who received the same message or phone call from the same business dating back to the amendments to the FTSA in 2021. Potential damages therefore increased for a 1,000-person putative class quickly to 6 and 7 figures.
Now, this is a very important point that Kirsten has given us because you have to be able to point to a signed document saying, yeah, you can call me using an auto dialer. In our case, which came after the 2021 amendments, sure, we had a document signed off on by the patient, which we attached to a copy of our motion to dismiss. Unfortunately, it didn't say you can use an auto dialer, which was kind of made it a little bit iffy, but it was one thing that we argued anyway. So it's very important if you have documents that are signed by persons that allow for contact, go back, look at them, make sure that they specifically provide that you can use an auto dialer. Otherwise, let's get ready to rumble. Kirsten, thank you. Please continue.
In 2023, the FTSA was again amended, but this time significantly restricting the scope of liability and ability to sue. So in May of 2023, Governor DeSantis signed legislation amending the FTSA, which significantly impacted future claims brought under the act, as well as pending uncertified putative class actions. Some of the key changes to the amendment included the definition of an automated system was now defined as technology used for the selection and dialing of telephone numbers. The earlier version of the FTSA defined an auto system as technology used for the selection or dialing. So this substitution of the word and for or provides clarity regarding the technology subject to the FTSA, as well as arguably limits application of the FTSA. Again, it includes the express prior written consent. However, this time there's no longer a need for a signature, a physical signature. It can be satisfied through an act of express consent, which includes checking a box indicating consent or responding affirmatively to receiving text messages to such an advertising campaign or an email solicitation. It also requires that the consent include the telephone number to which the called party authorizes calls to be made, whereas the prior version of the FTSA required the number of the signatory. Another amendment change that occurred was that it now requires express written consent provided for unsolicited telephonic sales calls. The prior version of 2021 only included telephonic sales calls. So it went on to define an unsolicited telephone sales call as a call made other than to, in response to an express request of the person called, primarily in connection with an existing debt or contract if such payment has not been made, to a person with whom the telephone solicitor has a prior or existing business relationship, and by a newspaper publisher or his or her agent. And a huge change that occurred from this amendment was the FTSA implementing a stop message, which would be included with a text message received by a consumer. So if a telephone sales text message is sent to an individual who does not wish to receive such message must reply stop to the number from which that text was received. The telephone solicitor will then have 15 days after receiving notice to stop sending text message solicitations and cannot send text thereafter except to confirm receipt of the notice. And finally, the amendment applies to any individual action filed after the effective date of the amendment and any putative class action not certified before the effective date of the act. A recent court decision that is very beneficial for businesses is the Soto League versus Everglades College. It was recently entered on January 3rd of 2024. This is where the court issued two separate decisions denying class certification and granting the defendant's motion for partial summary judgment. The court determined the plaintiff must plead and prove actual damages arising out of the challenge telemarketing, as well as a plaintiff may only receive a single statutory damage award per action, rather than per violation. Therefore, the damages under the FTSA are now limited to $500 per action or $1,500 trebled, not per violation. This decision significantly reduces the potential windfall for many putative class actions, capping the overall financial impact for each case rather than each individual violation. We will continue to monitor if this decision is appealed and provide a client alert if so. There are some requirements that the FTSA imposes, and these are easy to remember. A client or an individual or business should not place a call before 8 a.m. or after 8 p.m., the local time of the person's called zone. So make sure that your dialing systems implement these time restrictions, and remember that Florida does have 2 time zones. No more than 3 calls can be made during a 24-hour period, regardless of the phone number used to make the call. So again, make sure if you're using an automated dialing system, it is able to cap the number of call attempts to Florida area codes to no more than 3 calls per 24 hours. And if a customer responds stop to your message within 15 days after receipt, you must stop any future contact. Now, there is some good news for our clients and broker-dealers and investment advisors. In case you were thinking this could apply to brokers soliciting businesses, just know that there is an exemption that applies to your employees calling to solicit business. So under Section 501(604), there are 2 financial institution exemptions. The first being for a licensed securities, commodities, or investment broker, dealer, investment advisor when soliciting within the scope of his or her license. And the second being for a supervised financial institution or parent, subsidiary, or affiliate. And in this instance, a supervised financial institution includes a commercial bank, trust company, savings and loan association, credit union, commercial finance lender, or insurer. And remember though, if you are exempt, you still must comply with the 8 a.m. and 8 p.m. curfew of calling during those hours, and also must allow for the transmission of a party's name and phone number when calling. You cannot have caller ID spoofing.
Kirsten, thank you very much. Just a couple of observations. The case that she discussed comes from a circuit court, which is a trial level court in Florida. We'll keep an eye on whether the case is appealed, and if so, what the appellate court does with that decision, and we'll get out a client alert once we have an appellate decision, if one is forthcoming. That's number one. Number two, the discussion about how you can obtain consent to contact somebody. Mention made of the fact that you can check off a box. Well, to me, that seems that could be fraught with a lot of peril, because you know what the plaintiff will say. I didn't check the box because I didn't want to be contacted. Somebody else checked it. So it might, just as a matter of practice, be good to have initials placed beside the contact so that at least somebody signs off on it, and no one can say, well, somebody else checked that. I didn't do it. I didn't want to be contacted. That's the voice of experience of having dealt with a lot of these cases in a lot of different ways, and that's what you're going to get. So now we're on to Section 3, and Kaylee, tell us about applying the 2023 changes to the Florida Telephone Solicitation Act.
Thank you, Alex. And thank you, Taylor and Kirsten. I mean, we all just heard a lot about why the 2021 FTSA legislation really, opened the floodgates to plaintiffs' class action lawsuits under the FTSA, because the Florida law was just so broad and so encompassing, especially so much more so than the federal legislation that existed. And then, Kirsten spoke about how the 2023 amendments did limit that 2021 legislation to some extent, which made it more beneficial for businesses or entities that maybe were subject to accusations of violating the FTSA. So as you can imagine, when the plaintiffs' lawyers sort of expected that this 2023 limiting amendment was coming due in May of 2023, there was a rush to file cases so that hopefully the 2021 legislation would apply to those cases, because that law is more favorable to the plaintiff's side of the case. But it is important to note that if you have a case that was filed before the 2023 amendment became effective, but did not yet have class certification when the amendments became effective, then the 2023 amendment would apply to those cases that were maybe filed before it, but did not yet have class certification granted. On the flip side, of course, if class certification was granted before the 2023 amendment went into place, then those 2021 laws would apply and the amendments would not apply to those cases that already had class certification before the effective date of the amendments in May of 2023. There's also an attorney's fees and costs provision in the FTSA, and this did not change with the 2023 amendments. But as you can imagine, because there is this provision to receive attorney's fees and costs reimbursement for the prevailing party, this is really what makes these claims lucrative for plaintiffs' lawyers, especially in the class action lawsuits, because as you heard from Taylor and Kirsten, there are some caps as to the recoveries, something like $500 per violation or $1,500 if the damages are trebled. So not necessarily making a lot of money as a lawyer with the recoveries per violation, but you can seek attorney's fees if you prevail. So that's why these claims are so lucrative for attorneys to bring. So it is important to be aware of this provision, but again, it is for the prevailing party. So how does one recover attorney's fees under the FTSA? The FTSA provides a procedure for that. It provides a specific framework that does differ a bit from Florida's common law, where you would typically, need to spend money retaining an expert witness, proving that the attorney's fees and costs that you're claiming are reasonable, and a lot of factors that would be considered requiring testimony to that effect. But here, the FTSA does provide that attorney's fees would be recovered or can be claimed when an attorney submits a sworn affidavit to the courts, listing, the time spent, the attorney's fees that are claimed, and the costs that were incurred on motions, hearings, and appeals in the case. Then the trial court would be tasked with reviewing that sworn affidavit that was submitted by counsel for the prevailing party, and the judge would conduct an analysis to determine the reasonableness of the attorney's fees and costs claimed. So if the judge makes the assessment just based on a sworn affidavit by the attorney, obviously this is a more efficient, less costly, and quicker method to obtain attorney's fees than the typical method of having to retain an expert to testify on reasonableness. Therefore, this provision makes it, again, lucrative for these claims to be brought. Also, an award of attorney's fees will become part of the judgment and subject to execution as allowed by Chapter 55 of the Florida statutes, which discusses the methods for executing and collecting on a judgment. So important to note that that is available as well. Here's also some information about the Florida Do Not Call list that it's important to be aware of. So the Florida Do Not Call list is maintained by the Florida Department of Agriculture and Consumer Services, and we've provided some links here that you can access when you receive the slideshow after this call. But you can access the website, and on the website, it allows businesses to actually apply to purchase a copy of the Do Not Call list. That is a list that is updated quarterly by the Florida Department of Agriculture and Consumer Services. So it is important if you're a business to make sure you're maintaining an updated copy of the Florida Do Not Call list. And this list is completely separate from the federal Do Not Call list. So it's not a substitute to have one or the other. It would be advantageous to have both and remain up to date on the Florida Do Not Call list contents, because there's also a search function on the Florida Department of Agriculture and Consumer Services website that would allow, it's a free search. Basically, you can type in someone's name and their phone number to see if they're on the do not call list. But it's more effective if you have the entire list, if you are conducting calls that would fall within the purview of the Florida Telephone Solicitation Act. Now, you've heard the presentation from Taylor, Kirsten, Alex, and I, and we do have some key steps that you should take, questions to ask if you find yourself defending against a Florida Telephone Solicitation Act claim or find your business accused of violating the act. So ultimately, if you're accused of violating the FTSA, you should really immediately consider a strategy for defending against that claim. What information or evidence do you have to support your defense? You might want to look at the digital records of text messages or calls or other communications that you have and maintain those digital records securely so that you could use them if you ever have to defend against a lawsuit. It's important to create a timeline of events to track when the consumer first made contact with the business, what is the history of the business relationship with the customer, when and if consent was provided, what that consent consisted of, and if the consent was ever withdrawn. These are all really important considerations to know so that you could immediately mount a defense. As Alex has explained from his prior experience in the case he had, they really knew what the facts were, and that was an important part of defending against an FTSA violation. It's also important to understand the law that we've gone over today, which, part of the law applies, whether it's the 2021 amendments or the 2023 amendments. All of these are important considerations to help you be successful in defending against an FTSA claim. So we do have some key takeaways.
All right, so let's go ahead and do the key takeaways, Kaylee, and thank you. And Taylor, what's the key takeaway from your presentation?
Thank you, Alex. So one of the key takeaways is that the 2021 amendment to Florida's Telephone Solicitation Act created a private right of action, and the requirement of prior express written consent if the call will be made using an automatic telephone dialing system. And what I wanted to reemphasize again is that Florida's definition of an automatic telephone dialing system is much broader than the TCPA's. So, like I said earlier, it is possible that you may not be subject to the requirements of the TCPA, but could still be liable under Florida law. So it's really important to be aware of the telephones numbers that are being used and whether any of the recipients are considered Florida residents based off of their area codes.
Yes, and the 2023 key changes, which are favorable for businesses, include the revised definition of automated system, which arguably limits the application of the FTSA. Also, the prior written consent can now be through checking a box or affirmative consent. And as Alex mentioned, it's really important if you are going to use the checking a box option to maybe think about including a signature section as well, or an initial section, so that there cannot be any confusion as to whether the individual checked the box or not. And also it revised the definition to include unsolicited telephonic sales calls instead of just telephonic sales calls, arguably again limiting it to the individuals who there has not been prior relations with. And then also it included a safe harbor, which was the stop message. Once a company does receive that stop message, they will have 15 days to stop sending solicitations, and if not, then they would be liable.
And then from the end of our presentation, I do just want to note the attorney's fees provision because, as you may know, the only way to recoup attorney's fees in Florida is if there's a contractual or a statutory basis that entitles you to collect those attorney's fees. And that's what we have here. The FTSA expressly provides for an award of attorney's fees for the prevailing party. And it's important to note that unique circumstance here that the statute allows for submission of a sworn affidavit to seek attorney's fees. And then it's really the judge who makes that determination just based off of the contents of that sworn affidavit. So the judge, his prior experience as a lawyer, will assess it for reasonableness and make any sort of deductions that the judge finds necessary and reasonable for the claim. So that's another consideration to remember when defending against these FTSA claims.
All right, well, thank you for that presentation of key takeaways. If I could add just a couple of things here, let me focus on the attorney's fees and costs. Anyone who's litigated in Florida as long as I have has gone through innumerable fights about attorney's fees that involved competing experts, the production of a bunch of documents, depositions of lawyers who are claiming fees, and attacks on the credibility of the documents and how you keep your time records. None of that's going to change in terms of keeping time records. You're going to have to be able to buttress the amount of, quote, reasonable, end quote, attorney's fees that you seek. And it's going to be defined by the factors that are found in the rules regulating the Florida bar about what is a reasonable fee that you can charge your client for the services that are provided. The difference is that if the judge is going to make the decision, you may get away from the fights about experts. It doesn't mean that an opposing party is not going to bring somebody in who is a so-called expert. And I use the word so-called not loosely, and I mean it, because I've been in enough of these cases where I don't know what makes somebody an expert on attorney's fees other than, well, I'm an expert on attorney's fees because I charge attorney's fees. No, it's got to be a little bit more than that. But somebody may bring in an expert, so you may have to fight that fight too. Hopefully, since the judge is going to make the decision and you're going to keep good records, you may be able to say, well, you don't need to take my deposition because here's my affidavit. These are the fees. I've reviewed the bills. These are the fees that we charged. Our client paid the fees. And if the client was given a discount, make sure you point out, well, this isn't the total amount of fees we could have charged. This is with the discount that we get our client. You have to define what the contract is with the client. So hopefully we'll avoid a lot of the rigmarole that has gone into making these decisions. And it'll be, let me file it. We'll file the affidavit. The other side can file their opposition. Here's our bills. Redacting, of course, anything that may be attorney-client privileged or that is not a fee that you can recover, and the judge will make the decision. Now, having said all of that, please keep in mind one thing. In my experience, you're not going to get 100% of the amount that you ask for. There's going to be a haircut, and judges like to give haircuts of 10 to 20%. So with that in mind, maybe one way to look at this is to say, okay, what were the total amount of fees that were charged? All right, what would we take to go away without having to do battle about are we entitled? How much are the fees to which we are entitled? Now, keeping in mind, of course, out there in Florida, there's this no fees on fees unless a contract specifically provides for fees on fees. Now, that sort of grew out of cases, I think, involving contingency fees, where courts ruled that, well, a lawyer who's seeking fees under a statute in a contingency fee case, since the award of the fees is going to benefit the lawyer and not necessarily benefit anyone else, well, you're going to have to be able to prove fees, but we're not going to give you fees for litigating the issue of fees. I really didn't understand the logic of that ever, and I think maybe it'll be subject to attack going forward. But keep in mind, if you're willing to take a haircut, you may be able to get out of this very quickly without having to litigate this issue tooth and nail, because you're going to have to do that. I think that is most of the extent of our presentation today. What we'd like you to look forward to going forward in the future is the fact that we are going to do a presentation on attorney's fees in Florida, which will be a more in-depth dive into how you get attorney's fees in Florida. And not only will it cover security statutes, it'll cover other statutes as well. For our insurance company clients, we'll talk about statutes that apply in insurance cases. We'll talk about some other statutes like the civil theft statute. When can you get attorney's fees? And that's important because there are some little twists and turns to the attorney's fee statute about, what was there and when you filed the case and what was the burden of proof that you had. And we'll all talk about it under section 57.105 of the Florida statutes, which is the quote, frivolous claims statute in Florida. And that's important because one thing you have to keep in mind is that you may have to dance through a lot of hoops before you can get attorney's fees. You got to make sure that you serve your motion in a certain way, that you do it, you wait the statutory amount of days before you can serve it. So we're going to go through all of that when we go through our attorney's fees webinar, which you should look forward to be coming up in a few months. We do have a Q&A. Someone has asked a question. So the question is there a trend in the type of technology used to place calls by defendants? For example, are click-to-dial technologies being challenged as automatic dialing systems? Would one of our panelists like to answer that question? Never at a loss for words. Let me throw in something here. Beauty's in the eye of the beholder. To the extent that somebody can take the definition and say, well, clearly, this new technology, which wasn't envisioned at the time, but it clearly falls within the definition. And I think that's where we're going to have to litigate. I don't recall seeing a case decided under the Florida statute that focused upon the specific type of automatic dialer that was used. Now, remember the automatic dialing definition just came into play in 2021. And then it was changed again in 2023 and went from an or to an and. So we haven't seen any appellate decisions in that regard. But that's a very good question in connection with any follow-up we do relating to what we talked about today. We'll certainly look into that issue, and to the extent that we can provide you with an update regarding the Florida Telephone Solicitation Act, we will. So thank you for sending along that question. Anybody else have any questions? If you do, shoot us one on the Q&A. We'll be happy to take a look at them. Do we have any more slides? I think we have one more that we probably need to address.
Here it is.
There it is. So our code number 2 is, of course, anniversary. And those of you who were here at the beginning will appreciate the 2 codes that we use. So you're going to need the codes to get CLE credit. So make sure you've written down those 2 codes. And I think in addition that in a few days, we will have this webinar posted. It's being recorded. It'll be posted online if you want to go back and look at it, or if you need to look up again and see what the codes were, it'll be there for you. So again, I want to thank all our 3 panelists, our associates here in Florida for Bressler for their participation. And as we do our webinars in the future, certainly Taylor, Kirsten, and Kaylee will be a big part of those webinars. So they took the laboring oar in drafting the PowerPoint presentation and in putting together each of their presentations. So you can see the quality of lawyer we have here up and coming in the Bressler offices in Florida. So one last thing. And I want to reiterate this because it's very important to keep in mind. Know what the statute says. If you have a case pending in which the class has not been certified, jump on it immediately, go back and take a look and see what's anything you can do that maybe can short circuit the certification of a class. And if you get one of these cases, make sure you take a look at it, develop the facts. You got to know what the facts are. You got to know how the contact was made. Who made the contact? What kind of a system did they use to make the contact? Did somebody pick up a phone, make a telephone call, dial the number themselves, and say, hey, by the way, you got some benefits left on your insurance. Why don't you come in and see us? Or was it truly an automatic dialing system that selected the number, placed the call, and sent out a recorded text or recorded voicemail message? Because that is going to be, as we would say where I grew up in Central Florida, that's a horse of a different feather and something you really need to take a look at. So thanks, everybody. We appreciate your participation. Again, if you have any follow-up questions later, send them to us. We'll be happy to answer. So thank you so much. And ladies, would each of you like to say thank you to our guests?
Yes, thank you for attending.
Yes,
Thank
thank you
you.
everyone for being here today.
All right. And without further ado, wait a minute, we have another question. Just when you thought it was safe to go back in the water. No, thanks very much. Excellent presentation. Thank you so much, anonymous attendee. We appreciate your comments. And with no more questions, or anybody else to send in a comment telling us what a great job we did, we'll be happy to read them out. But I guess if not, thanks everybody. That's the end of our presentation. Ciao.